Imagine walking into a room and on the desk right in front of you, there's just this massive tower of paper.
Oh, yeah.
I'm not talking about a neat little stack here. I mean, a leaning tower of Pisa made entirely of legal documents.
Classic nightmare.
Right, like 500, maybe 1,000 pages. You've got petitions, affidavits, police reports, receipts from 10 years ago that have completely turned yellow.
And someone looks at you and says, you have 20 minutes.
Exactly. They say, tell me if we're going to win or lose.
It is pure information overload. I mean, for anyone outside the legal profession, that stack of paper just looks like, well, like a foreign language written in code.
If that were me, I'd probably just panic.
Yeah.
I really would. I'd start reading page 1, line 1, in the court of whatever. And by page 3, I'd be asleep or hyperventilating.
Most people would.
But today, we're doing something really interesting for this deep dive. We're going to fix that panic. We are taking a masterclass on how to actually read a case file.
And we aren't just talking about reading for the sake of reading. We're decoding what's called the advocate sequence.
The advocate sequence.
Right. This is about how seasoned lawyers actually think when they look at that absolute mess of paper.
And we should mention our sources for this. We're basing this deep dive on a really comprehensive set of guides from advocates Usha Vats and Manoj Parashar.
Yeah, they really break down the mechanics of legal strategy in a fascinating way.
So the mission today is simple. We want to give you, the listener, X-ray vision.
I like that, X-ray vision.
We want to strip away all the fancy legal language and show you how to find the story, the strength and the strategy in literally any dispute. So whether you're a law student, someone dealing with a legal issue yourself, or just insanely curious about how this whole system works behind the scenes, buckle up.
And what's really fascinating here is that the case file doesn't actually start with the case file.
Wait, hold on. Let's unpack that. If I'm physically holding the file, hasn't the case already started?
Paradoxically, no. The strategy begins long before a single page is ever filed in court.
Okay.
It starts with a warning shot. The legal notice. According to the breakdown of CRE litigation strategy from our sources, this is the formal first strike.
The first strike. I always thought a legal notice was just a formality or like a basic threat.
Well, it is a threat, but it's a highly calculated one. A legal notice is a formal written communication sent to a person or an entity. It basically informs them of a grievance and gives them an opportunity to resolve the issue before you initiate court proceedings.
Basically saying, fix this or we go to war.
Exactly.
But do you always have to send one? I mean, can't you just surprise them with a lawsuit, catch them off guard?
Right. In some cases, you actually can't. It's mandatory.
Really?
Yeah, the most common example of this is check bounce matters under the Negotiable Instruments Act, specifically the 1881 Act. If someone gives you a check and it bounces, you cannot just run to the judge immediately. You are legally required to send a notice within a specific time frame, giving them a chance to pay up.
And if you miss that window?
You can't file the case. The door has closed entirely.
Wow. So it's a gatekeeper. If you don't send the notice, you don't even get into the arena.
Precisely. But even when it's not strictly mandatory, like in recovery of money, breach of contract, maybe builder delays or defamation, it's still crucial because it creates a legal record.
It puts it on paper.
Right, and it shows seriousness. Honestly, it often leads to a settlement without ever having to step foot in a courtroom.
Because it shows you aren't bluffing.
Right. Look, if you receive a well-drafted legal notice via registered post or speed post, and by the way, you always keep that postal receipt, that receipt is absolute gold.
Keep the receipt. Got it.
It signals that the other side has already engaged a lawyer. They are spending money. And that realization often forces a settlement right there.
You mentioned well-drafted just now. I feel like if I were furious at a builder for, I don't know, delaying my apartment by 3 years, I'd want to write a really angry letter.
Oh, absolutely.
All caps. How dare you? Lots of exclamation points. Just let them have it.
And that is exactly what you should not do.
No.
No. The veteran move here is totally counterintuitive. You must be cold.
Cold.
The guide has this massive important tip. Never send a threatening or emotional message. A legal notice must be professional, precise, and legally sound.
But why? Wouldn't raw emotion show the judge how much I care, how much I've suffered?
Emotion weakens the legal case. If you sound unhinged, you lose credibility immediately. And worse, you might actually admit to things in your anger that can be used against you later.
Oh, I see. Like giving them free ammunition.
Exactly. You need to list the facts chronologically, state the legal provisions, make a very specific demand like, pay X amount and set a strict time limit, usually 7 to 15 days.
So no ranting.
Right. It shouldn't sound like a rant. It should sound like an inevitable conclusion.
Keep it cold, keep it factual. I like that. Now let's assume the notice didn't work. The builder ignored you.
Happens all the time.
So we are going to court. We have the giant stack of papers we talked about at the start. The source material breaks this down into two completely different worlds, right? Civil and criminal.
Yes. And the mindset shift here is absolutely crucial.
How so?
If you try to read a civil file with a criminal mindset or vice versa, you will miss everything. They run on entirely different operating systems.
Okay, let's start with the civil operating system. This is stuff like property disputes, money recovery, family matters. What is the civil formula?
The formula for civil cases is documents plus admissions.
Documents plus admissions.
Yes, and the winning strategy is preponderance of probability.
Preponderance of probability. That's quite a mouthful. How does that actually work in the real world?
Think of a balance scale. In a civil case, you don't need to prove you are 100% right.
You don't.
No. You just need to prove you are more likely to be right than the other guy. You don't need to slam your side down to the floor. You just need to tip it 51% in your favor.
Okay, 51%. That makes it sound a lot more manageable. So I have a 500-page civil file in front of me. I need to find that 51%. Where do I actually start? Do I read the index?
No, skip the index. You start with what they call the skeleton.
The skeleton.
This is a 2-minute scan of literally just the first page. You check the court name, the jurisdiction, and the parties. Who is the plaintiff and who is the defendant?
Just getting your bearings.
Right. But the single most important question you ask in those 2 minutes is, plaintiff exactly kya chahta hai?
Which translates to, what exactly does the plaintiff want?
Yes. You focus entirely on the relief claimed. Are they asking for money? Are they asking for a wall to be demolished? Are they asking for a stay order?
It's basically finding the goalpost.
Exactly. Yeah, if you don't know the destination, you can't understand the journey. It sounds obvious, but you would be shocked how many people read the whole story without checking what the actual goal of the lawsuit is.
That makes total sense. It's like using a GPS. You have to input the destination first before looking at the route. Once I know what they want, then do I read their whole story. The plaint?
You read the plaint, yes, but you use a filter. You skip the fluff.
The fluff.
Clients love to write long, emotional paragraphs about how betrayed they feel by their business partner. The judge doesn't care, and neither should you initially.
So what am I looking for?
You scan for 3 things: dates, money, and property details.
Dates, money, property. Why dates specifically? I think the money is the most important part.
You look at dates to check if the case is time-barred. There's a legal concept called limitation.
Okay.
If you sold me a house 10 years ago and I haven't paid you, you can't just suddenly wake up today and sue me. You might be too late.
Oh, so legal claims have an expiration date.
Exactly. And if you find that the date is past the limit, the case is dead on arrival.
Wow.
You don't even need to argue the facts. A sharp lawyer looks at the date and asks, is the cause of action still alive? If not, game over.
That's a massive shortcut. You could potentially kill a case just by looking at the calendar on page 2.
Precise.
So step 3 is checking the documents.
This is where the civil detective comes out. You match the facts in the story to the proof attached at the back.
Like a matching game.
Exactly. If the plaint says, we signed a contract on January 1st, you flip to the back and look for that specific contract. Is it there? Is it an original or just a photocopy?
Does it matter if it's a photocopy?
Huge difference in court. And you also check if it's stamped properly. In India, for example, if a document isn't properly stamped, meaning the requisite tax wasn't paid, it might not even be admissible as evidence.
Story says X. Document must show X. It's a very mechanical process. Now, what about the other side? The defense.
That's the written statement. And this is where the guide uses the word gold mine.
A gold mine. Why?
Because you are hunting for admissions.
Admissions. You mean where the defendant literally says, yes, I did it. Does anyone actually do that in a legal document?
Not usually directly, but in civil law, if the other side admits a fact, you don't need to prove it anymore. The court accepts it. It's done. The trick here is to look for vague denials.
What's a vague denial?
Let's say the plaint says, you owe me $10,000. And the defendant writes, I deny the contents of paragraph 3.
Seems like a denial to me.
It might not be enough. You often need to be specific. You need to say, I do not owe $10,000 because I paid it in full on such and such date via bank transfer.
Oh, I see.
If you don't deny it specifically, the court might legally treat that vague statement as an admission.
So silence? or just being lazy with your drafting can actually be taken as a yes.
In civil law, absolutely. So the strategy is to take a pen and mark every single sentence where the defendant slips up and admits something or fails to deny it properly. You are literally circling your free points.
That is wild. And that leads to the endgame.
Yeah.
After scanning the file, a lawyer asks 3 final questions to determine the strategy.
Right. Question 1, what is the weakest document? Question 2, what is the strongest admission? And question 3, is this case settlement worthy or a trial win?
That is so brutally efficient. It cuts right through all the emotional noise. But let's flip the coin now. Let's go to the high-stakes world. Criminal cases.
The stakes are definitely higher here. Liberty is on the line. Jail time. And because of that, the formula changes completely.
What is the formula for a criminal case file?
Criminal equals contradictions plus doubt.
Contradictions plus doubt.
And the winning strategy is beyond reasonable doubt.
Right. So in civil, you just had to be 51% right. In criminal, the prosecution has to prove it almost 100%.
Correct. The burden is entirely on the accuser. And the defense. The defense doesn't actually need to prove innocence at all.
They don't.
No, they only need one reasonable doubt to win. Just one solid crack in the story.
So you're not trying to build a castle. You're trying to blow one up.
That is perfectly put. You are a demolition expert in a criminal file. And it all starts with the FIR, the first information report.
The foundation stone.
Yes. You read it very slowly.
Yeah.
You check the date, the time, and the place. But most importantly, you look for delay.
Delay.
Yeah.
Like if the crime happened on Monday and I reported it on Friday.
Exactly. In criminal law, delay is highly suspicious. It gives the parties time to fabricate a story.
Ah, I see.
If there's a delay, the defense lawyer highlights it immediately. They ask the court, why did you wait 4 days? Were you consulting with lawyers and family members to cook up a false narrative?
That makes total sense. And the guides mention something called the civil disguise. That sounds almost sinister. What is that?
It's a very common tactic, unfortunately. Let's say you owe me money. That's a civil dispute, right?
Right.
But civil court takes years. So to pressure you into paying me faster, I file a criminal complaint saying you cheated me or committed criminal breach of trust. I'm basically trying to use the police to recover a civil debt.
That feels manipulative. Is that even legal?
It's an abuse of the process. A sharp defense lawyer spots this immediately and says, Your Honor, this is just a civil dispute dressed up as a crime. Quash it.
Because the police aren't supposed to be debt collectors.
Exactly. Identifying a civil disguise is one of the fastest ways to get a criminal case thrown out entirely.
That is fascinating. It's weaponizing the criminal justice system for civil gain.
It happens every day. That's why the next step in reading the file is checking the section-wise ingredients. You have to check if the facts alleged actually match the law.
Give me an example of that.
Take Section 506 of the IPC, which is criminal intimidation. The lawyer asks, was it a real threat to life or just empty words shouted in a heated argument?
I'm like saying, I'm going to kill you during a road rage incident versus actually showing up at someone's house with a weapon.
Exactly. The law firmly differentiates between heat-of-the-moment outbursts and genuine, calculated criminal intimidation.
It's all about the context.
Or take Section 406, criminal breach of trust. Is there actual proof you were entrusted with the property in the first place? If the ingredients aren't there, the legal recipe fails.
So you're breaking the charge down element by element. If even one element is missing, the whole charge fails.
Correct. And then you look at the evidence, the charge sheet. You look closely at the witnesses.
What are we looking for with the witnesses?
You ask, are they independent, like a random shopkeeper who just happened to see the fight? Or are they interested?
Interested meaning biased.
Right, like the victim's brother who already hates the accused. Biased witnesses naturally create doubt. And you also look at the recovery of evidence. Did the police actually find the weapon? Or does the paperwork make it look planted?
And all of this builds up to the big courtroom drama moment, doesn't it? Cross-examination. The source material has a golden rule for this that I found really striking.
Yes. This is honestly my favorite part of the entire analysis. The golden rule is jo witness bol nahi paya, wahi defense hai.
Which translates roughly to, what the witness could not say is the defense.
Yes.
Wait, explain that. I always thought cross-examination was all about what they did say, catching them in a lie based on their words.
That's the movie version. In real cross-examination, you look for silence. You look for evasive answers.
Really?
Yes. If a witness says, I don't remember, or I didn't see that part, those gaps are exactly where the doubt lives.
Can you give me a concrete example of how a lawyer uses that?
Sure. Imagine a witness says they confidently saw the accused at the scene of the crime. The lawyer asks, what color was his shirt? They say, I don't recall.
Okay.
You ask, was it raining? They say, I'm not sure. You ask, how far away were you standing exactly? They say, I can't say for sure.
I see where this is going. You aren't proving the accused wasn't there. You're proving the witness is totally unreliable.
Exactly. You are highlighting the negative space in their memory. You don't have to prove your innocence. You just expose the massive gaps in their version of guilt. That is where the reasonable doubt comes from.
That is profound. It's looking for what isn't there. The guides also list some senior advocate tips for both sides of the aisle. Let's hit those briefly.
Yes, these are incredibly practical pearls of wisdom. Tip 1. Never read a file in court for the first time.
That sounds really obvious. Do lawyers actually do that?
You would be shocked how many lawyers wing it and open the file in front of the judge. It's a recipe for disaster.
Good to know. What's tip 2?
Make a timeline. Chronology clarifies confusion. If the timeline of events doesn't logically make sense, the story is likely false.
And the third tip?
Mark admissions, not arguments. Don't take a highlighter to the other lawyer's flowery speech. Highlight the hard facts that are admitted by the parties. That's what wins cases.
Solid, practical advice. Now, before we wrap up today, I want to clarify some terminology.
Right.
Throughout these guides, there are all these Latin terms and legal jargon that lawyers just love to throw around.
We do love our jargon.
It feels like a secret code designed to keep the rest of us out. So I want to decode a few of the big ones that came up in the modern lawyer checklist from the sources. Let's do a quick lightning round.
Go for it. Let's translate them into plain English.
First one, res judicata. It honestly sounds like a Harry Potter spell.
It basically means stop hitting the replay button.
Okay.
If a matter has already been finally decided by a competent court, you cannot fight it again between the same parties. You don't get a do-over just because you didn't like the judge's result.
Fair enough. Next one, locus standi.
That translates to, do you even have a dog in this fight?
A dog in the fight.
It refers to your legal right to bring an action to court. If you aren't personally affected by the issue, you generally have no locus standi. You can't sue someone on behalf of your neighbor just because you're a nosy person.
Good to know. What about writ jurisdiction?
That's the heavy artillery. It's the special power of the High Court or the Supreme Court to issue direct orders to enforce your fundamental rights.
So you don't use it for a simple contract dispute?
No. It's what you use when the system itself, or the state, is violating your core rights.
Next term. Interim relief.
The pause button.
The pause button.
Yeah. It's temporary protection, like a status quo order, while the main case is still going on. It physically stops someone from, say, tearing down your house while the court takes 5 years to decide who actually owns it.
Oh, that is crucial. And finally, natural justice.
Fairness. It fundamentally means two things. First, audi alteram partem, which means you must listen to the other side before deciding.
Hear both sides.
Right. And second, nemo judex in causa sua, meaning no one should be a judge in their own cause. Basically, no refereeing a game you're actively playing in.
See, when you explain it like that, it actually makes total sense. It's not just fancy words. They're just basic concepts of fairness and logic.
Exactly. The jargon is just a convenient shorthand for logical rules that have been around for centuries.
Okay, let's unpack everything we've covered today because we've moved through a lot of dense material.
We have.
We started with the legal notice.
The warning shot. It needs to be cold, factual, and highly strategic. It sets the board before the actual game even begins.
Then we moved to the civil operating system.
Where the magic formula is documents plus admissions.
Right.
You scan for the relief claimed, which is the destination. You check the dates for limitation. And you hunt for admissions in the paperwork to tip the probability 51% in your favor.
And finally, we looked at the criminal operating system.
Contradictions plus doubt. You become a demolition expert. You look for a suspicious delay in the FIR. You check if it's a civil disguise meant to pressure someone. And you look for the gaps in the witness's story to create that one reasonable doubt.
You know, the biggest takeaway for me today is that reading a case file isn't about starting at page 1 and reading straight through to page 500.
Not at all.
It's about knowing exactly where to look. It's about finding the case story, checking the legal strength, and forming a court strategy right from the jump.
Exactly. It's an active process, not a passive one. You aren't just reading. You're interrogating the file. You're demanding answers from the paper itself.
So what does this all mean for us, the non-lawyers listening? Why should we care about checking ingredients and cross-examination strategies?
I want to leave everyone with a final thought about that golden rule of cross-examination we discussed.
The idea of looking for what the witness didn't say.
Yes. We live in an information age where we are constantly bombarded with files every single day. News articles, social media posts, corporate reports, political statements.
It's the tower of documents in our daily lives.
Right. And we naturally tend to focus on what is explicitly presented to us, the loud headlines, the bold text, the things people are shouting.
Sure, it catches our attention.
But critical thinking, true legal thinking, is about asking, what is missing here?
Right.
What specific question was not asked by the interviewer? What data was intentionally not shown in this chart? Who is completely silent in this story?
That is a really powerful tool to have.
If you can learn to spot the silence just as well as you spot the noise, you won't just be a better reader of legal files. You'll be a better, more critical thinker, period.
Next time you're reading the news, look for the silence.
Yeah.
Huge thanks to the authors of our source material, advocates Usha Vats and Manoj Parashar, for providing this incredible roadmap into the legal mind.
Indeed. It's a toolkit that works far beyond the walls of the courtroom.
And thank you for listening to this deep dive. Class dismissed.